I'm Florida foreclosure defense lawyer Michael Wasylik. I'm here in Dade City, Florida, outside the historic Pasco County Courthouse behind me, which is no longer functioning as a courthouse, but it does house the Pasco County Commission. The actual courthouse is now a couple blocks down the road. I'm here today to talk to you about one thing that comes up in many of my foreclosure cases, and it's the question of whether or not the bank that's suing you owns the loan. And I want to talk about why that's relevant in some cases, but why it's not relevant in most cases, why it doesn't matter. It's even a red herring that it's easy to get distracted by when you're looking at real legitimate defenses to your foreclosure case. Now, there's two ways that a bank can prove what's called standing as to your particular foreclosure loan. That meaning that they're the right bank to be suing you as opposed to somebody else who might have an interest in the loan. And the two ways the bank can prove standing are: one, by virtue of ownership. They can show that they actually own it, they bought the loan, that they bought it as part of a group of loans, such as in a pool or a trust, or that they bought an individual loan directly from the lender or through a series of intermediaries. And that is rarely the way banks try to establish that they have standing to sue. Instead, they normally rely on the second way that they can go about it, which is to prove that they are the holder of the note. And the holder of the note is a particular status under the Uniform Commercial Code, which is the statute, the law in Florida that governs how parties may enforce promissory notes, notes and loans of this type. The way to establish yourself as a holder is to simply have possession of the original note. So you've heard that, show the note defense, and that the note is either payable to you as the original lender or is endorsed in a way that allows you to enforce it either to you or in blank. And if you can prove as a bank that you have possession of the original note and the note's endorsed to you at the time that you file a lawsuit, you have standing as a holder. And if you have standing as a holder, it doesn't matter who the owner is. It completely doesn't matter. And so that's why most banks prefer to use holder status, because it's usually easier to prove than proving ownership through a chain of title. They don't have to prove the chain of title and holder status. All they have to prove is that each endorsement on the note existed at the time that they filed the foreclosure lawsuit. And as long as they're able to do that, they have established that they have standing to sue. So that is why ownership of the loan in most cases is a red herring. It doesn't matter who owns the loan, because if the bank that's suing you can prove that they have the holder status, they're going to establish for the satisfaction of the court that they have standing, and trying to challenge who the original owner is or who the real owner is isn't going to change the outcome of your case. And that's why usually when I am trying cases, when I'm litigating a foreclosure case, I rarely need to investigate whether or not this bank is the owner, because I'm usually trying to defeat them on the basis that they're not the holder, because that's the only thing they're trying to prove. If I can defeat that, I will win. So if you have a question about your foreclosure case, if you have a question about who the owner of your loan is, and now you might have a question about whether it really matters, go ahead and give me a call. My number is 352-567-3173. That's 352-567-3173. I'm Florida foreclosure defense lawyer Michael Wasylik, and thanks for taking the time to watch this video today.